Good morning. We are the arbitration panel. I am Dr. Dawn. In my professional life, I am Dean of the College of Law at the American University of Baghdad. I am also Vice President here of Academic Affairs. I'm American. I have an American law degree. I'm a practicing attorney, and I have expertise in alternative dispute resolution techniques, including negotiation, mediation, and arbitration. I will be your chair today. I am joined by two co-arbitrators who all have introduced themselves. Ahmed.
Good morning. My name is Ahmed Hamid Sakhar. I have a degree in law from Al-Mustansiriya University. I participated in the Bismuth in 2019, 2020, and 2021. I'll be your arbitrator, so nice to meet you.
Hello everyone, my name is Nawad Al-Amri. I'm from the Moot Alumni 2019-2020, and I've also participated as an arbitrator in last year's first ever Iraqi This Pre-Moot. Thank you.
Again, welcome. So this morning we have two teams. Our claimants are from Tishk International University. You are welcome. Our respondents are from Al-Iraqiyya University. You are also welcome. Before we begin, I just want to confirm you have both agreed to the time constraints today. Is that right? Yes. I believe it's 14 minutes per side, yes?
Yeah.
Good, okay. Thank you very much. Okay, so would the claimants like to begin, or the respondents? What have you agreed on?
We agreed on that respondent procedural side begins first.
You want them to begin? Okay, so the claimants have requested for the respondents to begin. Are the respondents ready?
We have agreed.
Wonderful, you may begin.
Respected members of the Arbitral Tribunal, good morning. My name is Muhaymin Turki, and my co-counsel is Muhammad Tahar. Together with my co-counsel, we represent respondent Jaja Bayfiul. I will be dealing with the procedural issues, and my co-counsel will be dealing with the merits of the case. I have one procedural issue. The parties have not validly agreed on the jurisdiction of the Arbitral Tribunal. It's contained two main points. The first one is the formal requirement necessary to conclude a valid arbitration agreement have not been met. The second one is the substantive requirement for a validity of the arbitration agreement have not been met. Moving to the first main point, it's contained also two sub-points. The first one is, under the Nubian arbitration law, the arbitration agreement was not validly included into alleged contract. According to Article 7, Option 1, Paragraph 6, which mentions that a reference to documents contain an arbitration clause, make it part of the contract. According to technical interpretation, the document shall be available to both parties, and the reference should be express reference to the arbitration clause itself. And the Singapore High Court ruled that the arbitration clause contained in the general conditions of sale required a clear reference to the arbitration agreement itself.
Myman, may I ask a quick question? Did you say the Singapore High Courts?
Yeah.
Singapore, the Republic of Singapore.
High Court.
Okay,
yes.
Thank you.
In the present case, there is no express or implied reference to the arbitration agreement contained in the general conditions of a claimant. And in the light of the discussion that occurred between claimant and respondent at the Palm Summit Oil, the discussions was about commercial matters. It is not about the general conditions and contents. Moving to the second main point, under New York Convention, the formal requirement necessary to conclude a valid arbitration agreement have not been met. According to Article 2.2, which mentioned that the writing condition is not fulfilled unless it's signed by both parties or contained in exchange of telegrams or letters. In the present case, in an Italian case, the Court of Cassation ruled that the arbitration agreement was not valid because it was signed by the buyer and it is not signed by the seller. In the present case, respondent did not grant its consent and it did not sign the contract between the parties, it's will subject to the general conditions of sale the general conditions of sale and its contents, the arbitration agreement.
Excuse me, counsel, but doesn't the parties have a practice where they don't need to actually send the signed contract back to the respondent?
It's correct, Mr. Arbitrator, but in the cases there is a discussion between the parties, and in the three cases, according to Ms. Bubati's statements, in the three cases, there is a change happened on the general conditions of sale before respondent signed the contract.
But there is a practice. You don't actually deny that.
There is a different roads here, Mr. Arbitrator.
Right, thank you. You can move on.
In the present case, as I mentioned, there is a respondent did not sign the contract between the parties, and the general conditions of sale did not come in any exchange between the parties. Moving to the second main point, the substantive validity of the arbitration agreement. The arbitration agreement, it's contained two main points, two sub-points. The first one is the CISG should govern the arbitration agreement between the parties. Pursuant to Article 1.1.a of the CISG, which mentioned that the CISG applies on the contract between the parties if these parties from different states and those states contracting states on the CISG. In the present case, respondent from Mediterranean and claimant from Equatoriana. Both Mediterranean and Equatoriana are contracting states of the CISG, and the contract between them about the sale of goods. And claimant COO at the Palm Summit Oil agreed with the respondent offer purchase that the contract will be governed by the law of Mediterranean, which including the CISG. And respondent head of purchase assistant confirmed that by an email, which is in the claimant exhibit C1. Page 17, please. And the third paragraph, the last line.
Which page?
Page 17.
Thank you.
This is an email from First Rain, who is claimant COO assistants, to Ms. Faulkner, who is respondent head of purchase assistant. The sale will be governed by the law of Mediterranean. Thus, the CISG should apply on the formation of the arbitration agreement. Pursuant to Article 6 of the CISG, which states that the CISG can be excluded by an agreement of the parties. According to Schwenzer, if the parties have an intention to exclusion the CISG, they have to include a clause into the contract about exclusion of the CISG. In the present case, respondent did not agree with the claimant to exclusion of the CISG from any part of the contract. Pursuant to Article 8.1 of the CISG, the conduct of the parties shall interpret by according to the party's intention. If the other party does not aware of the other party intent, it should be interpreted by the reasonable person in the same kinds and in the same circumstances, and take into consideration the negotiation that took place between the parties and the practice established between them. In the present case, claimant cannot be unaware of respondent's intention. Respondent from the beginning of the negotiation raised his objection of the dispute resolution mechanism which claimant adopts. And if the claimant cannot be unaware of the respondent intention to be bound by arbitration, any reasonable person can interpret that the respondent intention to be bound. And the parties have not practiced to include the arbitration agreement by practice between them. Moving to the second sub-point, even if the Nubian contract law is applicable, the arbitration agreement is still invalid. According to Article 2.1.6 of UNIDWA principle, which states that the silence or inactivity of the other party should not consider as an acceptance. In the present case, respondent did not grant its consent to the arbitration clause in the general conditions, which is non-provided to respondent. And the claimant did not send it in the negotiation between the parties, and the respondent did not have an opportunity to take a note of the general conditions contest. May I ask the tribunal to open page 18? At paragraph 6, please. She said that she would look into that, but never came back to me. Our respondent, claimant here, was request and writing consent to the contract when may I ask the tribunal to also to open Mr. Chandra's statement at the page. May I correct myself? It's in page 32. Respected tribunal, there is a different arbitration clauses here. This is the first part is before change in 2016, and the second one is the after change in 2016. The claimant provide that the general conditions of sale to Ms. Bubati in October 2011, when she was still working with the Southern Commodities, there was a different arbitration clause between the parties, and after the change, Mr. Chandra had not provided the general conditions of sale, which contains a new arbitral clause.
Excuse me, counsel, but wasn't respondent already aware of the change of the general conditions and did not have any interest in knowing the specifications of it?
Sorry, can you rephrase your question?
Did respondent know about the change in general conditions?
Respondent cannot be aware of the change of the general conditions of sale.
In the record, we have it on record that in the summit, respondent was aware of that. Respondent was informed about the change in general conditions, right?
At the summit, you mean?
In the summit, I believe, either in the summit or in a mail after that, respondent was aware of a change in the general conditions of sale.
Thank you for highlighting this point, Mr. Arbitrator. After the change, the general conditions of sale, a claimant, Mr. Chandra, said that in his statement, I'm not sure I sent it to Ms. Bubati, but...
Excuse me, counsel. I'm not talking about if they knew the specifications. I just want to know if they knew there is a change.
Respondent cannot be unaware of this change, Mr. Arbitrator.
You can move on.
May I conclude, Mr. Arbitrator?
Go ahead.
And to conclude, the parties have not validly, on the jurisdiction of the arbitral tribunal, because the arbitration agreement lacks the formal validity and the substantive validity for the arbitration agreement. Thank you, Arbitral Tribunal.
Thank you very much. Is claimant ready?
Members of the arbitral tribunal, good evening. Good evening. My name is Muhammad Rabe. I am here with my co-counsel Hussein Soran. We are representing claimant Elga PLC. I have one submission. In case jurisdiction of an arbitral tribunal is contested by a party, the tribunal itself has the power to rule on its own jurisdiction competence doctrine. The parties have agreed to use the 2021 Asian International Arbitration Center to conduct the arbitration proceedings. Article 20 Asian International Arbitration Center rules gives the arbitral tribunal has the power to rule on its jurisdiction. Because of that, my first submission, the parties agreed on the jurisdiction of the arbitral tribunal. In order to prove that, I have.
Excuse me, claimant, can you move the microphone closer?
Sorry.
Thank you.
Thank you. In order to prove that, I have two sub-issues. The arbitral tribunal has the power to determine the law applicable to the arbitration agreement. Therefore, the arbitral tribunal have to apply the Danubia law because the seat of arbitration in Danubia, and the Danubia law, it has closest and real connection with arbitration agreement. At the same time, Danubia law is the impartial law. It can be resolve any dispute between the parties. Because of that, my first issues, the law governing of the arbitration agreement is Danubia law. And even if the arbitral tribunal respondents claim that the arbitration agreement is governed by the law of Mediterranean instead of the Danubian law, the arbitral tribunal disregards the application of the CISG to the arbitration agreement regardless. Because of that, that's my second sub-issues. Even if the Mediterranean law is applicable, the CISG is not applicable to the conclusion of the arbitration agreement. Moving to my first members of the arbitral tribunal, moving to my first sub-issue, there are some reasons that's my first sub-issue. My first point, Danubian contract law is the governing law of the arbitration agreement. In the beginning, claimant mentioned in contract that the Danubia is the governing law of the arbitration agreement, and claimant general condition of sale has into the contract and mentioned in arbitration clause according to Article 9, and if you look at Record 6, paragraph 14 from the case. My second point is the arbitration agreement has the most real and close connection with the Danubian law under the New York Convention. The Danubian law has the most real and...
Excuse me, counsel, but why can't we apply the law of Mediterranean since it is the law of the contract? And the arbitration agreement is part of the contract, so why can't we apply the law of Mediterranean?
Because the, the parties have to Danube is governing the Danubian law, because the Danubian law is part of the arbitration agreement and is part of the contract law. And Danubian law, in the beginning I said, Danubian law is the impartial law. It's a best point to settle any agreement, to resolution any dispute between the parties.
You can proceed. Proceed with your argument. Move on.
Can you repeat again, Mr. Arbitrator?
I
please?
didn't ask a question. I said move on.
You can continue.
My second point is, I said the arbitration agreement has the most real and close connection with the Danubian law under the New York Convention. The Danubian law has the most real and close connection with arbitration agreement according to Article V1A New York Convention, to which the recognition and enforcement if an tribunal award may be refused if the arbitration agreement is not valid, the law to which the parties have subjected following any induction thereon, under the law of the country where the award was made, Article 36 1 a unilateral model law. The law is the verbatim adoption of the rule. My third point is the Mediterranean law does not consist the implied choice. The parties, although the parties have agreed and the parties already chosen Mediterranean law and to govern the contract according to record 52 procedure order number 2, and the law governing the arbitration agreement does not necessarily have to be the same as the main contract according to author born. And my fourth point is the parties validly agreed on arbitration. In the beginning, the parties agreed on the arbitration clause which had provided that the contract was to be governed by the law of Danubia, and the arbitration clause have the Danubia because in the beginning said the Danubia law is the impartial law, and it's a best point for resolution any dispute between the parties. And according to Article 7 adoption to unilateral model law, said the arbitration agreement is an agreement between the parties. Any dispute happened, they will be settled according to arbitration. And the formal validity of the arbitration agreement and the capacity of the parties and the substance validity of the arbitration agreement according to author Julian D.M. Liu. And my fifth point is, and even if the even if the tribunal assume Mediterranean law is applicable to the arbitration agreement. And the parties agreed on the law of Mediterranean as the applicable law. Because claimant in the beginning I can say claimant had also mentioned that under new policy contracts should be governed by the law of Mediterranean. And members of the arbitral tribunal, if you don't have any question, I will move to my second sub-issue.
Claimant, I had one question. You've said 3 times that Danubia is the impartial law.
Yeah.
So tell me the difference between Danubia and Mediterranean. Why is Mediterranean not also impartial?
I think if you conclude any agreement and if you want to be settled any agreement, the best point is working if the choose the impartial law for resolving any dispute between the parties. Because the Danubian court said the CISG rejected and Mediterranean law adopted CISG. And I think the Danubian law is the best point to resolve any dispute between the claimant and respondent.
Thank you. Carry on.
Even if the arbitral tribunal accepts respondents' claim that the arbitration agreement is governed by the law of Mediterranean instead of the Danubian law, and the arbitral tribunal disregard the application of the CISG to the arbitration agreement. Members of the arbitral tribunal, there are some reasons. That's my second sub-issue. And my first point is the CISG regulates only the sales contract. Pursuant to Article 1 CISG, and the subject matter of the CISG is the contract of sale goods. My second point is arbitration agreement differ from the sales contracts under the CISG. And my third point is, and the parties did not intend to apply the CISG to the arbitration agreement. And my fourth point is, the CISG should not be applied given that Danubia is the seat of arbitration. And my fifth point is, the arbitration agreement is not a sale of goods contract under the CISG's admit. Members of the arbitral tribunal, in conclusion, the law governing of the arbitration agreement is Danubian law. Even if the Mediterranean law is applicable, the CISG is not applicable to the conclusion of the arbitration agreement. And the parties agreed on the jurisdiction of the arbitral tribunal.
Thank you very much.
Thank you.
Okay, any questions from the claimants?
I think well, good.
Okay.
Respected arbitral tribunal, respected opposite counsel. There is a dispute between the parties that Article V, which states from opposite counsel, it's applied on enforcement and recognize the arbitral award. But the point is here, the parties have not expressed or implied agreed to apply the Danubian contract law on the formation of the arbitration agreement. In Solimarka case, the court found that if the parties have not indicate the law should govern the arbitration agreement, it is governed by the law of the main contract. Thank you, arbitral tribunal.
Thank you.
So, counsel, do you have a rebuttal?
No, I do. Answer?
You have a rebuttal?
Answer this question.
Yes,
Yeah. I said in the beginning, if you settle any agreement and any contract, resolution, any dispute between the parties, the best point is the choose impartial law for resolving any dispute between the parties. Which the impartial law can we conclude the arbitration agreement? The impartial law is the Danubian law. Thank you.
It's all good.
Yeah. Claimant?
Respected members of Arbitral Tribunal, good morning. As my co-counsel introduced me, my name is Hussein Soran, and we are representing claimant. And today I have two submissions to make. First thing, the parties have concluded a contract in 2020. The contract was concluded because respondent had made a valid offer through Ms. Bubati, which is head purchase manager of respondent. And he even discussed with claimant about the goods price and the quantities, which claimant wholly agreed to. Also, the general condition of sale were validly included into that alleged contract. The general condition of sale were included through a practice which the parties agreed to adopt. The practice was formed in previous transaction between claimant and respondent parent company, Southern Commodities, and because of that, the general condition of sale were validly included into that alleged contract. I will move to my first submission. The parties have concluded a contract in 2020. Respected members of Arbitral Tribunal, if you open record 10, claimant is Exhibit 1, paragraph 12. It shows us that on 1st April 2020, Mr. Chandra, which is claimant's COO, had received an email from Ms. Bubati in which she placed an order and asked Ms. Chandra to prepare the contract documents. There are some reasons that the parties have concluded a contract in 2020. My first reason is Ms. Bubati had made a valid offer. The two criteria for determining whether an offer has been made are the sufficient definition of a proposal, and the second point is the party's intention to be bound in case of acceptance. Under Article 14, Paragraph 1 CISG. In the present case, Ms. Bubati's words were sufficiently definite, and in the email, Ms. Bubati expressly described the goods to be RSPO, certified segregated palm oil, and the quantity should be 2,000 per annum. The price be paid $900 USD for the first year. The duration of the contract is between 2021 and 2025. And the model of the delivery is CIF Oceanside delivery in up to 6 installments. Claimant Exhibit 2, page 12. My second reason is
What's the page?
Claimant Exhibit 2, page 12, record 12.
Thank you.
My second reason is Ms. Bubati's purchase offer indicates the intention to be bound by the contract. A party's intention to be bound may be shown by its interpretation of its conduct or statement in accordance with Article 8, Paragraph 1 CISG. In the case, Ms. Bubati precisely described his email with the purchase offer. She used the exact words purchase offer, and she also said that I would like to make the following order with you, which indicates and define the email as an offer. Moving to my third point, respondent's offer became effective. An offer becomes effective when it reaches the offeree in accordance with Article 15, Paragraph 1 CISG. On 1st April 2020, Mr. Chandra received Ms. Bubati's email. On that period of time, the offer will become effective, and claimant return of the signed contract on 9 April 2020 amounts to an acceptance or counter offer to respondent's offer. Claimant Exhibit 2, page 12. Claimant Exhibit 4, page 17. Moving to my fourth point and my final point. Respondent's silence after 9 April amounts to an acceptance. In determining an intent of a party or the understanding, a reasonable person would have had due consideration to all relevant circumstances of the case, including the negotiation and the practice that was established between the parties. Under Article 8, Paragraph 3 CISG. In the present case, it was an established practice between the parties to acknowledge that an absence of an objection within 1 week by Ms. Bubati. Claimant Exhibit 1, Record 11, Paragraph 14. But in the present case, it was only on 30 October 2020 that respondent informed claimant of the termination of the contractual obligation, claimant Exhibit 7, page 20, which is more than 6 months and not a reasonable period of time to communicate an objection to a contract where there is established practice between the parties to consider the contract as concluded in an absence of an objection within 1 week.
Excuse me, counsel.
Yes.
You say that there's a practice between the parties.
Yes.
When this happened, in the last few times, the previous contracts, who were the parties of these contracts?
Can you rephrase your question, please?
When this alleged practice happened,
Yes.
it was between which parties?
It was between claimant and Southern commodities. But Mr. Arbitrator, we have Ms. Bubati who worked for Southern commodities, and claimant worked with Ms. Bubati, and they have a lot of contracts and an established practice between themselves. But
Excuse
after,
me, counsel,
yes.
if I may interrupt you again. So Ms. Bubati already knows this as a practice, but she's not here. When she negotiated the
Yes.
contract,
Yes.
she wasn't negotiating
Yes.
as Ms. Bubati. She was negotiating as an authorized signatory member and a negotiator of claimant, right?
Ms. Bubati?
I'm sorry,
Ms. Chandra.
of respondent, right?
Yeah.
So she was not there in the capacity of except signing on behalf of respondent, which is Judge Abaifio,
Yes.
right? So there's no practice between them.
Mr. Arbitrator, there is practice because every act that Ms. Bubati do, it's on behalf of respondent in accordance to Claimant Exhibit 2, page 12. Ms. Bubati negotiated the contract on behalf of respondent, and following the approval of the commercial terms by respondent, and she even sent an email to Mr. Chandra with her company's email address with the official logo of respondent. So thus every act that Ms. Bubati does is on behalf of respondent, and respondent is reasonable for Ms. Bubati's acts.
Thank you. You can move on.
Counsel, are the contracts between Ms. Bubati and Mr. Chandra enough to establish a practice? I mean, is there a specific number to consider that there is a practice?
I'm sorry, Mr. Arbitrator, can you rephrase your question?
Is there a number of contracts to establish a practice?
Of course, Mr. Arbitrator. There is around approximately 40 contracts between Ms. Bubati and...
Are they enough? Are they enough, 14 contracts? Is there an article in a law or an authority? Do you have an authority that says if there is a 40 contracts, there is a practice between parties?
Mr. Arbitrator, thank you. The practice is established between Ms. Bubati and Ms. Chandra. But now Ms. Bubati is the new head purchaser of respondent. The practice that was established between claimant and Southern Commodities conclude respondent as well, because Ms. Bubati herself chooses the previous routine that she does the contract with the old template of claimant, which includes the general condition of sale and the previous practice that was established between the parties.
Claimant, I have a question.
Yes.
So the contracts, the 14 that went back and forth, I believe 8 went without signature and then 6 came back because there were some changes, right? Now this one, they said they wanted to come back because of the changes in the palm kernel industry, the EU, the Red II, everything. So isn't it reasonable that claimant's company would have known about the changes and the change in the environment and everything, just like respondent knew about it? Wouldn't it be reasonable to assume that your client knew what was going on with the palm oil industry, especially the palm oil summit, the Greenpeace things going on? Wouldn't it have been reasonable that you would know they may not want to continue this relationship?
Thank you, Madam Arbitrator. In the palm oil summit, when Ms. Chandra talked with Ms. Bubati, Ms. Bubati was happy to hear that to be a customer to Ms. Chandra. So, no, I don't think so. Yes.
Carry on.
Yeah, thank you. I will move back to my fourth point. As I said, it was only on 30 October that respondent informed claimant about the termination of the contractual obligation, which is more than 6 months and not a reasonable period of time to communicate an objection to a contract where there is an established practice between the parties to consider the contract concluded in absence of an objection within 1 week. Members of the arbitral tribunal, if you don't have any question, I will move to my second submission.
Yes, you can move to your second submission.
Thank you. There are some, the general condition of sale were validly included into that alleged contract. There are some reasons for that. My first reason is the general condition of sale were included in past transactions between claimant and between Ms. Bubati and Ms. Chandra, sorry. In previous transaction, we can divide it into two periods of time. The first time is between 2010-2015, and the second time is between 2016-2018, because the application clause was replaced in the general condition of sale with the AIAC model law, but the rest of the content remained unchanged. Under the CISG, in order to be incorporated into a sales contract for the first time, the standard terms need to be a part of the offer, Article 14, Paragraph 1 CISG. That requires, on one hand, a clear reference by the offeror, and on the other hand, offeree's reasonable understanding of the standard terms, according to author Honold.
You have 1 minute left in the time.
Okay. My second reason is the practice was formed into a long-term and frequent transaction. This practice has a frequency of being followed from 2010 to 2018. Ms. Bubati had made 4 to 5 contracts on behalf of respondents with claimant per a year, and all the contract that was been made with claimant is approximately 40 contract, and according to Claimant Exhibit 1, page 9, paragraph 2. That means that the general condition of sale has been adopted regularly and consistently by claimant.
So, claimant, your time is finished.
Can I ask for 1 minute to conclude my argument?
Yes, yes.
Thank you. Claimant and respondent are bound by the previously established practice between claimant and Southern commodities. In the present case, there was no objection within 1 week, so the contract was concluded. The long-distance business relationship between the parties have concluded the new and the old version of general condition of sale. Thank you.
Thank you very much.
Respected members of the Arbitral Tribunal, good morning. My name is Muhammad Tahir, and I'll be dealing with the merits of the case on behalf of my client, respondent, CIA Biofuel. And to the case of the day, I have 2 issues I'll discuss. The first issue is whether the contract is concluded in 2020, and the second issue is the claim in general conditions of sale is applicable to the contract. Moving forward to the first issue, I have 2 main points. The first main point is whether respondent's offer lacks an intention to be bound. And the second point is that even if that alleged offer by respondent is proposed, claimant rejected that alleged offer by applying its general conditions of sale in the system on them. So it's called a counteroffer. Moving forward to my first main point. The CISG, according to Article 40, defines the offer, and it's makes difference between the definite effective offer and other statements in relation or behalf of the negotiation and concluding a contract, which one of its main elements, the intention to be bound. So therefore, in the case at hand, my client respondent did not have the intention to be bound to become an effective offer that Mrs. Pupati respondent had a purchase made in her email. Quite the contrary. On the email, she sent a mere order that only defecates the commercial terms that they had set it on the palm oil summit, but otherwise the intention to be bound was absent due to the fact 3 levels. The first level is when Mrs. Pupati herself responded to the purchase, the authorized. Responded to the purchase did not have the intention to be bound due to the fact that she's authorized, but yet she waited for the acceptance by her management, respondent CEO. So therefore, she returned within 3 days. Moving forward to respondent CEO and management did not have the intention to be bound to the fact that the most obligation that they had for that contract, that there must be an RSPO certification for that palm oil, which claimants entered to a scandal, RSPO certifications, which are they fake due to the fact that it's proved that 2 of its suppliers did not have the RSP certification palm oil. And moving to the 3rd level that I have to prove that my client did not have the intention to be bound, which is that my empowered client head of purchase assistants still have 2 open issues to discuss with the claimant CEO assistants. It made me to move to my second main point, which is that even if that alleged offer is rendered as effective, claimants rejected that offer by a counteroffer. According to Article 19, that a counteroffer, if an acceptance, even if an acceptance that have modified one of the main terms, it's not evaluate itself to be an acceptance, more of a counteroffer. At the present case,
But counsel, is the general conditions one of the main terms of the contract?
Actually, the difference that happened in that offer, that is the dispute resolution, which is one of the material of the offer. So therefore, when it's had its modification, there is a counter offer that had been made to the default modification. So when the modification that had made at the counter offer by claimants toward respondent did not accept it, that counter offer, which is projected, and may I refer to Arbitral Tribunal to page 12. May I correct myself, it's page 11 of the record. On page 11, my opposing counsel stated that within a week is the amount of time to conclude the contract or to raise an obligation. Actually, within a week is the time of an acceptance to that modification if happens between the parties, to that according to paragraph 13 of claimant's CEO statements, that the documents within a week she accepts them. Leading me to those facts, to my third point, which is that respondent did not accept by not sending a side contract. There is practice established between the individuals and not the parties over the 10 years on 40 contract that happened between the parties. And according to the Court of the Appeal of Paris and the Supreme Court of Justice of Netherlands, that a rejected general the courts rejected the acceptance by silence too. It's not evaluated to become an acceptance in any way, due to the fact that if the party does not have an obligation but yet stays silent, it doesn't amount to be an acceptance, which had in the case at hand, that my client did not accept it, the counter offer that had been made, but it's still ongoing negotiation due to the email that have been sent from my respondent head of purchase assistance, Mrs. Falconer, to respondent to claimants, assistant, Mr. Rain. And that email, and I refer to the tribunal for page 31. Sorry, 30. In the fourth paragraph, she stated, in the third paragraph, she stated that there is also two issues I would like to suggest change to the acceptance term of the contractual documents. Therefore, and by that fact, which is projecting that there is still ongoing discussions and ongoing negotiations on the contractual documents, there is no acceptance to that contract, therefore it's not concluded. However, it's from responsibilities of the opposing counsel to show at least at that meet, but yet the opposing counsel did not respond to that email. Moving me forward, if the arbitral tribunal does not have any questions.
Counsel, I have a question. So now you say that there's no practice between the parties, right?
There is a practice between the individuals.
And the individuals in the previous contracts, they were concluded. Were they concluding the contract, signing it, as their representatives or on behalf of themselves?
As a representative, sir.
And now they're doing it exactly like they did it before, right?
Exactly, for certain.
So what's the difference here?
There is no difference, Mr. Arbitrator.
So if there's no difference, wouldn't it be reasonable to assume the practice is still ongoing, especially since Jajabay Fuel is a subsidiary of the same company that established the practice between respondent and claimant, and we have more than 10, I believe more than 10 people in Jaja Biofuel that worked in the same company that established the practice, right?
Correct, Mr. Arbitrator, but however, when I said that the practice is established between the individuals due to the fact there is a still ongoing relationship between the individuals themselves, but however, the Jaja Biofuel itself have a separability, character for itself, and therefore, when the practice happened between if the practice does extend to the contract, to the contractual concluding, it had nothing. Actually, there is 35 of the contract, which is the majority, 80% of the contract is concluded. There is a sign and return. So I guess the majority is competes.
Do you have any authority to cite on this? Do you have any authority on this?
Authority on what exactly, Mr. Arbitrator? May I refer a question?
On your answer, you're saying that there's no practice because it's actually practice between individuals. It was established by individuals and not the actual parties. Do you have any authority on that?
It's actually an analyzation from Article 8 to according to reasonable person.
All right, thank you. You can move on.
Thank you. Move on to my second issue, which has two main points. The first main point is that respondent head of purchase assistant does not have the acknowledgement of the existence of the general conditions of sale. And the second main point is that the mere reference to the general condition of sale does not amount itself to become applicable. And the first main point Supreme Court of Justice, the Austrian Supreme Court of Justice, that in the standard terms included merely if they are offered to or send it to the other parties to take look at, to take notice of, and know its content. So therefore, when there is no copy of it sent to the other party, and the other party does not have the enough acknowledgement of the content of the general conditions of sale, it does not amount itself to become applicable. And in the present case at hand, my client's head of purchase assistant does not have the acknowledgement of existence of the general conditions of sale due to the fact that when it came to discuss about the arbitration clause that happened, a dispute rose around, but they thought that it was in the contract, the paragraph 7.7, and not otherwise that it is in the general conditions of sale. And it was a responsibility of and a burden of proof, according to Hablus, page 18, that it's a burden of proof that the party wants to amend it and apply its general condition must send it to the other party. Therefore, in my client respondent, head of purchase assistant, does not have the acknowledgement. However, she empowered. So therefore, it's responsibility of the opposing counsel to send the to send the general conditions of sale. Moving to my next point, that a mere reference does not evaluate itself to become applicability to the general conditions of sale, which I have led. The mere reference of itself, according to Article 18, does not evaluate itself to become a part of the general conditions of sale. That if the other parties do not have the prior knowledge, nor the practice established between the parties, nor the acknowledgement of its existence, it's not evaluate itself to become applicable, and therefore the claimants did not meet. May I ask for an extra minute?
You have 1 minute.
All right. My clients did not have the altered after 2016 copy of the general conditions of sale, nor it's available at the claimant's website. Therefore, there is no way that my client had the prior knowledge or the accessibility to the content of the general conditions of sale. So I don't believe that it should be applicable. Does that tribunal have any question?
Actually, I do have a question, counsel. Did the respondent know about the change in the general conditions?
My client may not have about the modification, but the mere modification and not the whole contact that made.
So respondent did know, but had no problem with what the change actually was. Isn't that implicitly saying I'm fine with whatever it is? Because respondent did not show any interest in knowing what the actual change in the general conditions were. Really?
It's claimant's responsibility to show that what is the general conditions of sale content actually. So therefore, my client did not have the obligation before. He did not know. It's not known actually what the general conditions contain. So therefore, respondent to the purchase assistant thought the paragraph 7.7 was where the arbitration clause should be. So that is two issues that they discussed that I aforementioned, and not the general conditions of sale. So that the main two discussions, two issues that they should have, and claimant did not show.
And what is your authority on this?
My authority is actually according to Article 8, the CISG.
Thank you.
May I conclude? Therefore, the general conditions of sale is not applicable due to the fact that not a prior knowledge or the acknowledgement of the existence of the general conditions of sale, and the mere reference is not included enough to, it's not sufficient enough to include into the contract. Thank you.
I don't have any questions.
If I may, Mr. President Abdullah, do you have any rebuttal to the opposing counsel?
No, Mr. Arbitrator.
All right, thank you. No, actually, it's up to you to finish the arbitration session, since we're all done. I think this is
Okay. So thank you very much, claimants, respondents, teams. We now conclude this session. Thank you for being here. Thank you for preparing. We learned a lot. Thank you very much.
Thank you as well.